I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
I'm Jim Cheatham, and I'm here today to interview Claud R. Wheatly, Jr., attorney in Beaufort, North Carolina. This is one of the historical video series for the Chief Justice Commission on Professionalism. Claud, you've been practicing law in Beaufort for over 60 years. Did you grow up in Beaufort?
Born in Beaufort.
Born in Beaufort.
Yes.
I understand your father also practiced.
He started here in 1908.
There's a historical marker coming into Morehead City stating the first North Carolina Highway Patrol troop in 1929 was organized here. What do you know about that?
My father was a highway commissioner back in the 20s. There were 6 of them, and this is before North Carolina had a highway system. Each county had its own roads, and this highway commission started building roads. The fact is, the first road that built was Highway 10 that went from Beaufort to Asheville. And after it was built, the pavement was put in. The roads were only about 18 feet wide, as I recall, and highway deaths began to increase. And so it became necessary for the state to do something about it. So the Highway Commission decided they would look into the highway patrol concept, which they did. And they modeled it on Pennsylvania, started the highway patrol. In fact, my father made it his business to see that the patrol was organized to a certain extent. The meeting was here. In fact, the last meeting before they made the big trip to Asheville was on our porch here in Beaufort. And the picture was taken of that group. I was in it, 11 years old, so I was asked to unveil that plaque you're talking about.
Well, now, so you were the mascot, so to speak.
Well, maybe so. Maybe that's a good term.
But now they've had, the marker was just unveiled in the last year.
This summer, yes.
Where did you attend college?
I went to the Citadel a couple of years, then I transferred when I decided I was going to law school. I went to the University of North Carolina, and I went on to the University Law School.
Now, you received your license to practice in 1941.
1941, that's correct.
In the summer of 41. Now, did you
passed the bar in August 41.
Now, you didn't go right into practice with your dad then. He was looking for you, wasn't he?
Yeah, I went sailing, and he finally caught me, made me go to work.
Yeah.
In fact, carried me up to the court in October to be sworn in front of Judge Frizzell, our resident judge.
Right. Now, I understand one of the first cases you had as a young lawyer was defending a man accused of attacking a preacher with an axe handle or something.
No, that wasn't my case. That was my father's case. That was a case in which, right after I was sworn in as a lawyer, that October term, who, by the way, that term was attended by Mr. T.C. Wade, our ex-clerk of the court. Mr. Wade always came to court on Mondays to hear the judge charge the grand jury criminal terms. And he was sitting in the bar while I was being sworn in with his chair leaned back against the rail, and he had his normal quota of what he called flim cutters in the morning. And as he was sitting back listening to Judge Frizzell swear me in, Judge Frizzell suddenly, after he finished, said, "Welcome, young Mr. Wheatley. We welcome you to this ancient and honorable profession." Mr. Wade's chair came down on all four legs. I heard him say, "Ancient, right. Honorable, hell no." But Judge Frizzell kept right on going. He didn't let that bother him. Anyway, it was right after that I went over with my father and sat down. He had the first case for trial in that criminal term. And that was a case where the preacher claimed that he had been assaulted with an axe handle by somebody doing serious personal injury. And it appeared that on the cross-examination, my father asked him if he hadn't asked the defendant's wife to go with him to Chicago to be his handmaid, as the Lord had spoken to him in a vision and told him to take her. And when the defendant found that was happening, and he went out and saw the preacher sitting on his porch waiting for her, he was accused of assaulting the preacher with an axe handle. Now, the defendant testified when he took the stand that after he saw his wife throwing clothes in the suitcase, stating that she was going to Chicago with the preacher, he asked her why. She explained about the vision. He said he went on the porch and he got a few words to the Lord himself. And the Lord told him to take that axe handle and go out and knock the so-and-so out of the preacher, and that's exactly what he did. Well, of course, that tore up the courtroom. They thought that was quite interesting. My father asked Judge Frizzell if talking to the Lord business didn't work on both sides of the criminal docket. He said, did his court, he dismissed the case. I immediately wrote Professor Coates, my criminal law professor at Chapel Hill, and told him everything he told me about criminal law was wrong. I just learned how to try a case.
Claude, your law practice was interrupted by World War II. Tell us about your service.
I enlisted in the Army and wound up at Fort Sill, where I was commissioned, field artillery, and spent the next 4 years in the 78th Infantry Division.
You had our friend Pew Bailey was in that division, or
yeah, Pew and I were together for about 3 years, I guess, in that division.
In Germany, or
well, no, Pew. When we went to Europe, when Pew went to Europe, he went to Europe in the 106th Division. He was transferred to another division. Division Artillery. He was also in the artillery.
Right. Well, now, after the war, of course, you came back, started practice again, and got married.
Yes.
To Alice, and I believe, how many sons do you have?
Only 4.
Oh, 4 boys.
Yes.
Well, now, did all of those boys attend the Citadel?
Yes, all 4 of them.
All 4 of them.
I was trying an Admiralty case in Charleston, and my oldest son, Rob, had gone with me. He was about 16. And while I was trying that case, he was roaming around Charleston and went out to the Citadel and saw it and liked it. And I had told him about being there a couple of years. So that's where he went, on his own, and his brothers followed him.
Well, now, he ended up going to
Yes.
law school and practices with you today.
That's correct. He's here.
Tell us about the story about picking up your two sons at the Citadel in Charleston to bring them home from college in your sailboat named the Miss Alice.
That was his end of his sophomore year, and my son David's freshman year. And I sailed down and sailed back. I thought that'd be a great adventure. Turned out to be a disaster. We ran into almost a hurricane offshore sailing back, and we managed to get home Saturday, about 4 days later.
Well, now, and in talking to David and Claud Jr., I understand they don't like sailboats. Haven't sailed since, have they?
Oh, well, they've sailed since, but they prefer the quickness of power.
One of your sons, Claud Wheatly III, now practices with you. The name of the firm, as I understand it, is Wheatly, Weeks, Valentine, and Lupton.
Right.
They just had one member went on the bench.
We lost John Nobles, yes.
He went on the bench.
And that, let me say, is to the state's great service, I hope.
Now, years ago, you were invited to join the American College of Trial Lawyers.
That was back in '68, I guess. I think that's about right. And I received a letter relating to the American College. I didn't even know what it was. I'd never heard of the American College before. I thought it was another organization that was probably trying to get me to subscribe to a directory of some type. And I sort of ignored it. And I proceeded to get telephone calls from certain lawyers, all of whom were members of the American College, who I had tried cases against in the past year or so. John Anderson in Raleigh, Tom White, Kinston, and a couple others.
Yeah.
And they were all members of the college. And they wanted to know why I hadn't responded. And they told me what the college was about, and so I did respond. And that year I was admitted to the American College. I think in that time there were only 22 members in the state. I was the 23rd, I think.
You were asked, I believe, to compile the number of cases, admiralty, civil, and criminal, that you had tried up to that time. How many were there?
We had about 1,600 that year. That included everything.
Admiralty,
criminal, what would be the district court, recorder's court, everything you could possibly imagine. I was amazed at how much of the stuff we had really handled.
Well, and you were practicing litigation constantly.
Yes, I stayed in litigation.
Now, Claud, once when I was visiting your office, when your office was backed up to Taylor's Creek, I looked in your window and saw a pistol under your desk. Can you explain that?
The reason I had it in the office was because when that episode I'd had with a client who came in, who I had represented in a land suit, and we'd won the case. But it was one of those cases that was very, very dismal for me. I didn't like the way he acted, didn't like my client. I was hooked with the case, but when I finished that case, I made up my mind I didn't want that client anymore. Well, in about 6 or 8 months, he had another case, which I refused to take. He got another lawyer, and he lost the case. And he blamed his loss on me. He said, if I'd tried the case, he'd have won it. In any event, one Friday afternoon, he came into my office and told my receptionist that he wanted a drink of water, and she let him inside the gate, came inside, and instead of stopping at the water fountain, he came on back to my office and interrupted my conference with a couple of clients, stood in the door, and I told him to go back and sit down. He pulls out the pistol, and I proceeded to, he came in and said he's going to kill me. And when he pulls out the pistol, comes and sits down, my clients, of course, I got them out of the office, but with his consent. And then he proceeds to, says he's going to take me out. So he marches me out. And as we go through the lobby, all our clients are sitting there. They were quite shocked to see me being pushed out of the office with a pistol between my shoulders, and it hit the sidewalk. We go down to where his car was parked. He directs me to drive the car. So when I move around on the other side to get on the driver's side, I get the car between us. I spot my son who knew the event. He had just joined me that Monday. This was Friday. And I saw him walking down the sidewalk, and I was afraid that this man, his name was Green, would see him and turn around and fire at him. So I started cussing him in a very loud voice. I'm sure I insulted half the passengers on the street. But anyway, I did it very loudly, called him all kinds of violent names. And he was trying to shoot me through the windows of the car. And while he was doing this, Rob comes up behind him and grabs him. And I run around and get the pistol. As I got the pistol, I started to hit him in the head with it. Because that was the first time I really was getting mad with him. And Rob stopped me. Meantime, the police got there and arrested him. Rob and I walking back to the office. He'd been with us, though, that was, as I said, this was his 5th day. And he asked me one question. He said, "Daddy, is the law business always this hazardous?" I told him, "I hope not."
Well, that
So I carried the pistol to the office from there on.
From there on.
Yeah.
What special cases that you handled in Admiralty come to mind?
Oh, that was the Potomac. Potomac was a T5 tanker. That's the biggest tanker that the Navy has. And it's a civilian crew, and she was tied up over at the aviation fuel terminal, which is just opposite the port terminal. And this tanker was carrying at that time avgas, which is high octane gas for airplanes, as well as jet fuel. Our Air Force at that time still had a lot of prop planes as well as the jets. And this tanker had deep tanks forward, what they call deep tanks forward, in which the avgas was carried. And right after the deep tanks were jet fuel, and behind the jet fuel were additional avgas. Well, you've got 2 lines that go ashore, the pumps aboard the tanker. And in this instance, you try to have the tanks being drawn from simultaneously so the vessel will not become unwieldy, so she'll maintain her level. And so in order to do that, the mate who does the arrangement for the discharge use what's called the sea line. These tanks all have a sea line that they use for washing the tanks when they're at sea after they've been unloaded. And the discharge is through the sea suctions. Well, the sea suctions are tanks that are on either side of the ship. They go down about 14-inch diameter pipes. And these are always locked shut when the vessel is loaded at the place, say in Houston, where this tanker was loaded. They locked these sea suctions closed. There's a big gate valve on them. Well, as this tank was being unloaded, or tanker was being unloaded, and the fuel was being pumped ashore, the sea line that connected the various gas tanks had to bypass the sea suction. Well, unfortunately, the sea suction was locked open instead of locked shut. And so thousands of barrels of this stuff just gravitated overboard, went through the bottom of the ship. The tide was rising, water was running in towards the bridge between Beaufort and Morehead, and beside that bridge was a trestle for the railroad. And long about sundown, a lot of fishermen would go walk on that trestle to fish, and they had these little Coleman lanterns that they would light, drop down close to the water to attract the trout or whoever, whatever was swimming there. And when they did, the vapors were rising off the water from this tremendous amount of jet fuel that was floating on the surface of the water, and it ignited. And the flame danced across the waters right on up to the bow of that ship, crawled inside that ship, set those forward tanks on fire, and the ship was burned. It was a terrible fire. It was one of the most violent fires that we'd ever had. You could see it all over the waterfront. And after the case, after it was over, the vessel was pulled up, or what was left of her was pulled up on a shoal nearby the area. But the Navy would not allow anybody to go aboard it. Well, I was employed by the terminal. We represented the terminal because the government who owned the ship accused the terminal of allowing the fuel to escape. They thought the fuel came from the terminal. They didn't know about this sea suction I've just told you about. Neither did we. We employed a diver who went underwater and went to this ship. And when the tide was falling, he was able to feel the water coming out of where those sea suctions were. And he knew that that suction was open from feeling the water coming out. When the vessel was carried to dry dock in Norfolk, we got a court order, put a Marine surveyor aboard, and found what I've told you about the sea suction being locked in an open position. We later had to run the mate down, who, by the way, happened to be in Honolulu, and let him describe how he had used that sea line so it did cross and participate in the discharge. But anyway, that was the story. The case was tried. We tried it. It took 2 weeks to try the case. It took about 12 years to finish it because the government was very violent in its efforts. He went to the Court of Appeals, went to the Supreme Court of the United States on certiorari.
Yeah.
But we finally won the case.
Right. Well, now there's one other, I've heard several, but that I think is interesting. There was a tugboat going down off maybe Savannah or Florida and got in a storm and sank, and that with only one survivor or something. Tell us about that.
Well, that happened to be my first admiralty case. And I had had very little training in admiralty. They didn't even teach it at Chapel Hill when I was there. The only law book I had was Robinson on admiralty that I paid $5 for. And I did my best to learn something about it. But this was a tug owned by Woods Towing Company in Norfolk, was employed to pull a tug that belonged to the government from Norfolk down to Gibbs's yard in Jacksonville, Florida, which had been broken down. They wanted to take it there for repairs. Now, as the tug reached Charleston, South Carolina, the radio on the tug failed. Well, the captain couldn't find a repairman very quickly, so he left without a radio and continued on down the waterway till he hit the St. Johns River. Well, the St. Johns River flows in instead of out. It goes in towards Jacksonville. On the banks of the St. Johns River, you have jetties that stick out about every mile or so, and they poke out into the river quite a bit. And heavy fogs, a lot of times, are on the St. Johns. And as they're moving up the river, going towards Jacksonville, for some reason, heavy fogs came in, and the tug struck one of those jetties. Well, that jetty was only about 2 miles from the Coast Guard station. Dark because of the fog. And when it hit the jetty, it hit with such violence with that tide pushing it as well as the power of the vessel. it knocked a big hole in the bottom of this tug, and it started sinking. Well, they were unable to get any help. Radio was dead. They couldn't call it the Coast Guard station or anybody else. The government tug somehow got loose and floated away. They couldn't use that for a life raft. And the tug went down. It drowned everybody but one crew member. And I represented the widow of one of the seamen who lived here in Carteret. And the vessel owners had a limitation action filed in Norfolk. Well, a limitation action is an action in admiralty where you contend that there was no negligence or any liability or any unseaworthiness on the part of the vessel, and you ask that any claims on the part of the seaman be limited to the vessel itself, and of course that was non-existent, so there was no value. The case came on for trial in Norfolk. So I made a claim for this one seaman, but in the meantime I located that survivor, found him in Asheville of all places. And he told me the story about the radio. Well, with my claim, I claimed that the vessel was unseaworthy because the radio failed. Well, we have a rule in Admiralty that if the vessel has equipment, and of course it breaks down while the vessel's at sea, there's nothing much they can do about it. But if they have an opportunity to repair it, don't, then of course that could affect the seaworthiness of the vessel. Well, this was my contention. When I got to Norfolk, I found out that I was out of order because I was not a member of the Virginia Bar. So I went to employ an old gentleman named Mr. Oakes, an old admiralty lawyer in Norfolk. Told him that I wanted his services in this particular case. He wanted to know what my theory was. And I told him that it was unseaworthiness because of the lack of radio. Well, he proceeded to give me a lecture that vessels had been going to sea since the ancient of days without radios. He didn't think that made a vessel unseaworthy. I said, well, I thought maybe it might. And I mentioned a case in the Fifth Circuit, and I thought gave us some precedent. We went, and the judge bought it. We won the case. Something interesting in that case, though, while I was sitting there, I discovered that the captain of the vessel had 4 wives, all 4 of them in there claiming. These wives were scattered everywhere from Boston down to Georgetown, South Carolina.
4 wives.
4 wives, that's right.
Well, now this area we're in around Beaufort is famous for storms and hurricanes. There was a bad hurricane some years ago in which the Dunes Club out on Atlantic Beach ended up, part of it, across the highway after the hurricane.
Right.
And I believe you were hired to pursue a claim against the insurance company because they denied liability based on the fact it was water damage, not wind damage. Is that
right.
correct?
That's right.
Tell us about that case.
Well, as you know, you probably heard about it, these recent hurricanes, the big fuss they're having now in New Orleans about is it wave wash or was it wind?
Yeah, right.
If it's wave wash, of course, the companies deny liability. If it's wind, of course, they were stuck. Anyhow, that's what they contended in this case. John Anderson, by the way, tried that case. He defended the insurance company. There were 12 of them. I think there were 12 companies on this particular policy. Anyhow, the major defense that they had was a engineer that they'd brought in from Charlotte. And he had established a water level on the beach by the use of some instrument, and he had computed that the water level would have struck the side of this Dunes Club building at a certain distance above the ground. Predicated upon that, it was his expert opinion that the Dunes Club washed away and didn't blow away. Well, we had some evidence showing that pieces were blowing off the Dunes Club before water ever got up. But anyway, at the end of his testimony, which was about 5 o'clock in the afternoon, I realized that was going to be the major defense. It was the most dangerous part of the case so far as we were concerned. I got back to my office thinking how I was going to cross-examine that gentleman. And as I was looking out my window, which of course abutted the harbor, I saw an old fish box floating down the water, floating on out. The tide was falling. He was about half under the water, half up. And I got the idea of maybe tested him on his ability to determine really how much water it took to float something. I walked down to a fish house a couple of blocks down the street, got a fish box, put it in one of their tanks to see how much water it took to float it, and I found out. So I took it to the courthouse. I also got the tables on flotation, which of course I questioned him about. He knew nothing about it, to the dismay of the judge, who happened to be an engineer himself before he went to law school. And then I asked him if he had determined how much water it took to float the objects that created the building.
The specific gravity?
Yes, and I had carried with me the specific gravity tables. And I asked him about specific gravity. Well, he didn't know what I was talking about. Well, that, of course, upset the judge. I noticed he was holding a pencil in his hand. And he was a little bit upset with me because I was pressing his engineer compadre, we'll say, pretty hard. But when he said he didn't know what specific gravity was, I saw that pencil pop in his hand. And I knew that the judge had finally gotten on my side. And I then proceeded to ask him, since he could determine the amount of water it took to float that big building, he could certainly tell me the amount of water it would take to float this fish box. Oh yeah, he could do that. I said, well, come down and put the line on it after you have computed the water line on this fish box. I said, when you get through, and I had a wash tub full of water, I said, they'll be going to put it in here to test you. Well, when he heard that I was doing that, he backed off and wouldn't do it. Said it was going to take too much time. Well, I pressed him on that. He refused to try it. Well, the more I pressed him on trying to compute the water line of that fish box, the more the jury laughed. Well, I knew then I was beginning to get on the good side of the case. But anyway, we won the case. Later on, when I was joined American College, John Anderson proceeded to tell those people that I wasn't much of a lawyer. I didn't use law books to practice law. I used fish boxes.
Concluding about the Dunes Club insurance case, that ended up the jury finding that it was wind damage, not water damage, that caused the
That's right.
liability, and thus you won. The insurance company had to pay full restitution. Right?
That's right.
Well, now, I do recall a case that you've mentioned about a water tower, a water case that was right interesting. Tell us about that.
Well, that was the case where we had a fire on a cold December night. In fact, there was about 2 or 3 inches of snow on the ground. And the fire company had pretty well put the fire out, but just before they had really completed it, the water ran out of the hydrant. And by they tried to back the truck down on a dock and draw water from the harbor, but by the time they did that, the fire had caught up and burned down 3 or 4 buildings down Front Street of Beaufort. And we sued the Carolina Water Company, which was the water company that
Furnish the city water?
furnished the water, that's right. As that allowed the water to fail to be pumped into the tank. What had happened, the pump had a float on it, and as the water would go down in the tank, the float would go down, caused the pump to work, and automatically. There was nobody there. There was no, at that particular time of night, the man who was supposed to be there was home in bed. And the water in the float had frozen, so that when the water ran out of the float under the ice kept the float up, so it didn't go down and start the pump. Anyway, we sued the water company. There was a contract between the town and the water company, very simple contract, 3 or 4 lines, which merely said that hydrants would be rented to the town by the water company at $60 a year per hydrant. That's all it said. We'd won the case in front of the jury, and on appeal, Mr. Dawson from Kinston was defending the water company. And he argued to the Court of Appeals that the contract between the water company and the town merely said $60 a year for hydrants. It made no mention about water. So when I got up to answer his argument, one of the justices asked me, said, Mr. Dawson made that contention that their contract didn't require the hydrants to have water. I advised the court, to the best of my ability, that Beaufort was a poor town. We certainly could not afford $60 a year for hydrants just for the pleasure of our canine population. And the court bought that. That's the last I ever heard from Mr. Dawson about no water being in the hydrants. We won that case, thank the Lord. That case became quite an interesting case. I notice it's in most of the tort books in law schools now.
Yeah, I think I've seen it in one of them. Well, now, you know, when you came back after the war, started practicing again, there were some judges both of us remember as being excellent judges, Judge Fountain, Frizzell, and Cooper and all. They didn't make a whole lot of money, though, then, did they? How much were they making?
I think the judge's salary was $7,500 a year.
Yeah. But they were dedicated and generally...
They certainly were.
Good
Every
judges.
judge that you mentioned was a dedicated judge, did his best, worked hard, and if the case was going to be prolonged quite a bit, I've tried them right on through Saturday. In fact, I tried one Sunday afternoon.
Yeah.
These judges did their job. They felt it was their duty to clean up that calendar.
Right. Well, you know, and there's a little difference now. I don't know. It's maybe the attitude or some of the younger judges are not as disposed to do that.
Well, that's true. That's true. The fact is, I've had a judge not very recently to tell me we didn't finish by Friday, as he was going to be busy the following week. He was going to declare mistrial.
Yeah.
Unless we settle the case.
Right. Well, now, I think we've talked about before, but you feel, and I tend to agree with you, a lawyer that becomes cantankerous in the courtroom or does something out of the ordinary, unfair attack, that doesn't always produce good results for him, does it?
I've always found that the lawyer who, if he was attacked by his opponent or even got harsh treatment from the bench, the jury felt great sympathy for him. And if he kept his composure, was the sufferer, so to speak, that usually helped him.
Yeah.
And it was always a great mistake, I felt, to fight back, try to protect yourself. As one person once described it, be the suffering servant.
Right.
And this is something that young lawyers need to learn and need to know. Don't go in there and be the arrogant pusher. If you are being mistreated, we were, take it.
Yeah.
Respond best you can. Try to explain whatever you got to do, but don't fight back. Don't use harsh language.
Yeah.
We tried a case. John Nobles and I were involved in a case in Raleigh, criminal action. Several years ago, it was a drug case. There were 6 people. It was a very involved drug case. Judge Boyle was the presiding judge. And for some reason, he got on John. John tried to get, I dropped out of the case. I had to come home. I got sick. And he got on John. And he was very violent in his statements to John. He was very harsh to John. And when the jury verdict came in, John's client was the only one that won. He was found not guilty. The others 5 were acquitted, and the jury came out to speak to John.
Yeah.
And that happens sometimes.
That's right.
You know, you never know what's going to appeal to a jury. The first case I ever tried was a criminal case. I had 3 young men charged with rape on this dwarf, deaf and dumb, by the way. And the evidence was really insignificant. But it was a local case, and the people made a great effort. The court realized, the state realized that it was weak in its presentation of evidence, and they had 27 charges against these 3 boys. Well, when I got ready to go to the jury, I was trying to think of something to attract their attention. And I thought about the old story of the mongoose. And I knew they'd never heard of a mongoose, but I thought I'd tell the story anyway. So I told them there was a man who had snakes in his yard, and he'd heard that mongoose would take care of the snakes. Well, he found a book in which somebody apparently spoke about somebody who raised these things. So he wrote a letter. Said, "Dear sir, send me 2 mongoose." Well, they got to look at that letter. Is that right? So he tore that letter up and wrote another one. Said, "Dear sir, send me 2 mongooses." Well, he got to looking at that letter, and he wasn't sure that was right. So he wrote a 3rd letter. "Dear sir, send me a mongoose. And by the way, while you're at it, send me another." And I told that jury that's what the state was doing in that case. If you can't convict him on this one, pick him on this one. Well, I won the case. The judge was quite amazed that they returned not guilty 27 times. When the jury was discharged, a couple of jurors came over to me and said, "Claude, tell me that mongoose story again." That's the only thing they remembered about the case.
That's right.
So you never know
What's
going to impress the jury.
Sure. Well, now, don't you think nowadays, with so much competition among lawyers, sometimes they tend to maybe take a case doesn't have any merit, or they let the client tell them what to do or how to handle a case instead of advising the client. Do you see that now?
I noticed that most young lawyers have to cross that bridge. They're sitting there, in comes the client, especially if it's a malpractice case.
Yeah.
And the client insists that there's sufficient evidence for the malpractice action or any other action, and there isn't. And the young lawyer knows that. But the client says, "All right, I'll pay you $10,000 retainer. I want you to do it." Well, the temptation is great. He does it. He brings a case, charges this doctor or this lawyer even with malpractice, and there's absolutely no legal basis for the charge. It's a Rule 11 situation to start with. The young lawyer is really hooked, is in trouble, and a lot of judges will see that, and a lot of judges will call that young lawyer in and advise him of the danger that he's exposed himself to. But one of the great temptations in the law is to let our clients come in and say, "Now this is what we expect you, sir, to do," and we stupidly follow that demand on the part of the client. it's hard sometimes to have a client that you have to come in and make the demand, and you tell him you haven't got a case. He insists that he has. Well, you haven't. You haven't, and I'm not going to bring it.
Right.
That's what the lawyer has to do.
Right.
And we do it daily.
Claude, there are going to be some young lawyers looking at this video. Is there any advice you can give them about how to proceed in arguing a case and being prepared?
Well, not only do I want to speak about preparation being the absolute essence of a trial practice, but also want to say that just because your opponents are experienced trial lawyers and you perhaps are a beginner, don't let that frighten you. Go after it. Look into the facts of the case. Because they are experienced and elderly doesn't mean they're right. Go ahead and take a look and see. Get prepared. Look for the situation. Look for the situation as it is. I had a case one time involving Mr. Theodore Kahneman, a Greek gentleman who had been in this country very long, whose English was broken and so forth and so on, didn't know what was happening half of the time with the new modern techniques that he was experiencing. And he owned some land in the western part of Morehead City. He ran a restaurant in the eastern part of Morehead City. And he gave an option of this land to a man named Blue. Mr. Blue, without exercising the option, took possession of the land without a Kahneman even aware that he was doing so, and started building a house on it. He paid his labor until his money was exhausted. Then he started floating checks, which bounced, and he left the state to avoid prosecution. The materials that were used in the house were all bought on credit, and of course all the material furnishers came in demanding that a Kahneman pay the bill. Well, the Kahneman knew nothing about the construction. There was no contact whatsoever with regard to construction between a Kahneman and Blue. Suits were filed to enforce the materialman's lien that was filed against Kahneman's property. 9 of them. There were 9 suits. And I attempted to represent Mr. Kahneman. I realized these 9 lawyers were going to be difficult people to handle, but I looked into the case the best I could, and I found a case that I felt was excellent precedent. I filed demurrers on the ground that the complaints failed to state a cause of action. Judge Hunt Parker was our trial judge. I didn't know Judge Parker. I had heard that he was quite a tough judge to go before, but by the same token, I was going to do my best. At the call of the calendar, I advised the judge that we had 9 demurrers. He immediately proceeded to tell me the court didn't have time for frivolous argument. He didn't say so, but it was obvious to me that he had very little use for young lawyers that were attempting to challenge the power of these elderly gentlemen who were opposing me. But I insisted that if he would give me an opportunity, I thought I could present the demurrers very quickly. There, go ahead, I will see you. I say I will hear you for a few minutes. I'm very busy. I'm very busy. Yes, sir. So I called the court's attention to a case that I think was entitled Brown versus Wilson. It had been written, the opinion had been written by Chief Justice Stacey. The facts were almost identical with the facts of these 9 cases. And Justice Stacey, in his method of writing, he was very short. He didn't expound like we see a lot of opinions today. But he started off this way. The court cannot take a Janus-like attitude in a case of this type, looking eastwardly at the contract and westwardly at the title to the lands. It must see both simultaneously. When I said that, Judge Parker asked me, he said, "Did you say Janus?" I said, "Yes, sir." Then I attempted to explain to Judge Parker that Janus was a two-faced Roman god, looking east and west simultaneously. He immediately jumped me, told me he didn't need any explanation as to who Janus was, and that he wanted to see the book. So I handed him the book. He read the case, in fact, read it twice. That advised us that he would see all lawyers in chambers. Well, in chambers we crowded. Only one chair. Judge Parker sat down to the chair, lit a cigarette, and proceeded to tell us how Romulus and Remus founded Rome on the 7 hills, and how these gods came into effect. He's talked about Janus, the power of Janus, how Janus looked after the legions of Rome. After about 30 minutes of this lecture, we went back to the courtroom where he said he was ready to rule on the demurrer. He immediately advised he was sustaining my demurrers and told me to prepare an order. I told him I'd already prepared 9, one for each case. They were very short. He looked at them, threw them away, said they'd never do, that he would prepare an order. So he recessed court for the rest of the day, and he and the court reporter wrote a consolidated order for all 9 cases. I think it ran about 4 pages, referred to Janus in several paragraphs. Anyway, I won the case. I later was in Raleigh, and I was telling Joe Cheshire, a friend of mine, about it. Joe said I shouldn't be surprised with that sometimes if you pass Judge Parker on the sidewalk and he didn't speak to you, it's because he was thinking in Latin. So that was the end of my big case with Judge Parker. By the way, after that, Judge Parker and I, when he later became Chief Justice of the Supreme Court, he and I always remained good friends. And I think it's because of Janus.
Claud, we appreciate your coming today, and this concludes the historical video series. Thank you.
Well, I appreciate the honor that you gave me by asking me to come.